Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my law partner David Nachman. David, welcome.
Thanks so much, Michael. Always a pleasure.
So we have to start with the cutoff dates for the month of November 2015. The family first preference, which is for the unmarried sons and daughters over the age of 21 of US citizens, advances by 3 weeks to February 22nd, 2008. The family 2A category, which is for the spouse and children under the age of 21 of green card holders, advances by 4 weeks to May 15, 2014. The F2B category, which is for the unmarried sons and daughters over the age of 21 of green card holders, advances by 3 weeks to February 8, 2009. The family third preference, which are the married sons and daughters of US citizens, also advances by 3 weeks to June 15, 2004. And the family fourth preference, which are the brothers and sisters of US citizens, also advanced by 3 weeks to March 1, 2003. Now the employment preference categories for all other countries are current, including India actually. For all the countries is current. But don't think that this will always be current. We have a feeling that sometime in the future it may establish a cutoff date, but right now it is current. The second preference employment category is current for most of the countries except India. The cutoff date advances by 1 year and 2 months to August 1, 2006. It has been going back and forth. Last time it went back to 5, now it is back to 2006. The third preference, professionals and skilled workers, there is no movement in the world countries except India. Actually, India moves by 3 weeks to April 1, 2004. Same thing with the EW other workers category, advances by 3 weeks to April 1, 2004. The employment fourth preference, which are the special immigrants, religious workers and priests, is current for all the countries. The EB5 investment category is current for all the countries. So this is the regular bulletin that comes every month from the Department of State, and we have been giving you this information. What is the importance of this? The importance of this is that you cannot get a green card or immigrant visa processing or even applied for adjustment of status previously. We will talk a little bit in a minute. That has always been the case. People who filed the petition and in the family preference cases had wait many years, and they have to wait until the visa number becomes available. Sometimes people get confused when they get a letter from NVC, oh, my case has come, not yet. So these are the cutoff dates, very important, that every month has been coming for many, ever since we started practicing law. I mean, this has always been there. But there is a change that has taken place now since last month. And what is that change? The change is that we discussed in the last program that for whatever reasons, the Department of State and the Immigration Service both combined came with a policy. They say, okay, here is the deal. Those people who are living in the US here, legally in the US, and they are eligible for adjustment of status, because if you are not eligible, then it does not matter at all, you cannot apply anyway. But you are only waiting for the visa number to become available. Those kind of people, they have given a separate second kind of bulletin that if your cutoff date is such and such, that even if your visa number is not available in the first bulletin we talked about, you can still apply for the adjustment of status. Very good news. It's not just for us or the clients, it's even good for the government, and David will explain you why it is good for the government also. So what are the dates of that you have a I-140 approved or I-130 approved, and the person is living here legally and eligible for adjustment of status or under legal status or under 245I, can now, I give the dates, file the 485 application, and then you can get a EAD, permission to work, permission to travel in most cases, and be done with it. At least then you have not to worry. Then the visa number becomes available, the government will pull your file and approve it, because you already submitted them what you need. Okay, so here is the second bulletin, adjustment of status dates. The date for the F1 category, which is the unmarried sons and daughters of US citizens, is May 1, 2009. The 2A category, which are the unmarried sons and daughters under the age of 21 and the spouses of green card holders, the date is March 1, 2015. The F2B category, which are the unmarried sons and daughters over the age of 21 of green card holders, the date is July 1, 2010. The family third preference, which are the married sons and daughters of US citizen, the date is April 1, 2005. And the fourth preference, the brothers and sisters of US citizen, the date is February 1, 2004. I mean, it's not a big jump like, 5 years or 6 years, 3 years. At least 1 year or 2 years in most of the categories you can file in advance of the visa number becoming available. Now, in the employment preference category is current anyway for all the countries. F2 category, which is the advanced degree, is current for most of the countries, and for India you can file it if your priority date is before July 1, 2009.
Yep.
Okay, and the other workers category, the date is
Well, third preference skilled workers is July.
2005.
Correct. Yep.
Same thing. So basically, these degrees, these categories, if you see, has a bigger jump. For example, EB2 category, the cutoff date is 2006. So if this wasn't there, you will be waiting for another 3, 4, 5 years.
So it gives individuals an opportunity to apply
3 years in
early.
advance of the visa
That's
number.
right, to have work authorization and a travel document. So essentially what it is that it's advancing the system so that they're not being held hostage. So it's very nice.
Right.
And it also advances their ability to utilize portability under AC 21.
Exactly.
Because once the adjustment of status application has been filed, as most of our viewers know from prior discussions that we've had, Michael, that after the PERM application has been approved, or the I-140 has been approved, then the adjustment of status is pending for 180 days under AC 21 Section 106C. The individual is allowed to move to a new employer in the same or similar occupation.
Not only that, the spouse, husband, wife of the person,
Right.
by filing a 485, she or he gets permission to work also,
That's right.
right?
That's right.
So,
Exactly.
so this is great. It's great, good news for many, a big relief for many people
Right.
that are.
And the individuals also had, remember with the employment authorization for spouses under H-1B, where the I-140 was approved, so they can apply for work authorization also.
Yeah.
So
Anybody who files a 485 under this can get.
correct.
Yeah, not only the principal applicant, the family members, and maybe children also.
So you asked an interesting question before, Michael. You said, why is this beneficial to the government?
correct.
And I
To the
think that one
government.
of the things going back to that is, of course, now what the government has is an opportunity in advance to be able to review the file and to vet the file, and then to actually be able to almost grant the green card close to the actual priority date.
Yeah.
So essentially what this is it's a ramping up period for the government, an opportunity to review the files in advance of when they actually hit the priority date.
See,
So that's
if you
very
recall-
beneficial.
If you recall, David, in our last programs we did explain in details that Mr. Oppenheimer, who's the person in the Department of State, we both know him, every month he makes a decision. So what happened in 2007, August of 2007, one day he got very upset when he found out that the visa numbers that were allocated to the American consuls and to the immigration were not fully utilized. So on one hand, people are waiting in line 4, 5 years. On the other hand, they are going to the visa numbers going to the garbage. So he got very upset. He says, what can I do to force them to use every number? So he said, okay, here it is. All the categories, employment categories current.
Yeah.
And that made a lot of people who are watching this program today, many of you might have already filed a 485 in 2007, and then they had to wait a few years until the visa.
Well, I think that he made a lot of immigration lawyers very upset because we had to work some very late nights to file all those adjustment of status applications.
I know.
But Michael, you opened the door to a very interesting question that I'd like to discuss with you, which is commonly referred to, for those of you who are doing some research online about this issue, called VisaGate. And VisaGate is referred to by our colleagues as sort of what happened here when this new bulletin was promulgated, and then all of a sudden what they did was they announced that there was a mistake that was made to the second bulletin, and they pulled back some of the numbers. So what happened was that a lawsuit, a restraining order, was filed in the courts, in the federal courts, with an attempt to pull back the numbers to the original numbers.
In the 2000, for the EB2 main thing in our was 2011, but then they made a change in the policy, says 2009.
Right.
So one of our,
Well, they said it was a miscalculation and that they had to readjust it.
so one of our colleagues, a lawyer who filed a suit, and them saying that they should go back to 2011.
It was a class action lawsuit that was filed in the federal court, and our colleague had mentioned that what he was saying is that unfortunately that we should go. Well, he was saying fortunately we should go back to what the other number was. And
David, I had 90%. I know it won't pass because they were comparing to 2007, that August that happened, where the people had already filed. It was more complicated. Government had accepted the fees. It was very difficult for them to reverse it. But this was just a temporary restraining order thing that we.
right, and well, I wanted to point out to our viewers that actually Michael Rabindra Singh and myself had written an extensive article about why we felt, and this was before the actual case was decided, we had predicted that the case was going to be denied. And we actually had done an analysis as to why we felt the case was going to be denied. And since many of us in the firm have had some litigation experience, we knew what the analysis was going to be by the court. And we took a look at the complaint that was filed with the court, and we saw that what happened was that they had actually asked for a form of specific relief. It's a form of chancery practice where they were asking for a restraining order. And a restraining order is very specific relief, very difficult to get, not easy to get, but you're only entitled to a restraining order if you can't be compensated in money damages. Exactly. And the problem is that in the complaint, what they did was they actually laid out that the individuals who were harmed had spent a tremendous amount of time and money, and they mentioned money right in the complaint, and that was probably not the way that they should have gone about it.
Not only immigration, in every, I tell you, I had a case where somebody claimed that he had the rights to screen the movie. So he went to the federal court to get a restraining order that this movie should not be done. The judge says, well, you can calculate the compensation. If he has done something wrong, exactly, the court will grant you that compensation. So
that's when you're not entitled to the restraining order.
So,
exactly.
A famous singer, I cannot tell her name because we represented her. So this is very, very important, basically, to tell you the advantages of that. And the last point I want to say, some question coming from people all the time. How does this affect the visa processing? Now, we talked about adjustment of status. The second bullet, we are talking about people who are physically here and trying to get a green card in the US. But what about those whose parents' family is in India or other countries? There's not a major change, but there also there's something going to happen. They have told the National Visa Center to speed up the completion of the papers. In other words, instead of 3-4 months in advance, maybe a year or two in advance, they will start telling them you can pay the fees, you can complete all the paperwork, affidavit support. This way, all the visa processing case files are completely ready to go. They cannot miss the numbers because they are asking for 100 numbers and all the 100 files are there, then just issue to them. So this is another good reason, but that will move faster. That may this is the loss of losing the visa numbers. If that is taken care of, then there are extra numbers that we previously losing can be utilized. Exactly. That will make the line.
And that's what the president wanted to do. Exactly. Michael, I think we have just a minute left, but I would like to make an announcement about the TNEC International Film Festival, which the NPZ, Nachman Fawani Zimochek Law Group, has been actively involved in for many years. And we've actually brought Bollywood to Cedar Lane in Teaneck, New Jersey, once a year. This is going to be held actually there's going to be a screening of a special movie and also a recognition of Ken Nas,
who is chairman, CEO of the Eros International.
Of Eros International, and he was good enough to make a very special film available to us. The screening will be held on Friday, November 6th at 7 o'clock at the Teaneck Cinemas, which is located at 503 Cedar Lane in Teaneck, New Jersey. Everyone, of course, is welcome to that screening. Ken Nas, of course, will be there, and so will we. And the name of the film...
Full one will be there.
Exactly, and the name of the film is...
Dil Dhadakne Do. In other words, when David Nachman is looking at Priyanka Chopra, the dil dhadak, let it pump. Okay, with that, I think we come to a conclusion of the program. We thank you very much for watching the program. Please keep watching us every Saturday and Sunday at 11:45 a.m. Thank you.